March 30, 1939. The Supreme Court of the United States is now in session. Chief Justice McReynolds presiding. United States v. Miller et al. Mr. Gordon Dean for the United States for the appeals. Chief Justice McReynolds looked around the courtroom. No one volunteered to speak for Jack Miller or Frank Layton because no one was there on their behalf. Well then, Mr. Dean. Gordon took a deep breath. He had prayed that no opposing legal counsel would show up, and when he had learned that no brief had been filed, he realized that his prayers had been answered. An opponent to challenge what he was about to say would have doomed his argument. Without opposition, there was a chance he could squeak by. All it would take was some creative manipulation of the facts and some monumental omissions. Yes, Your Honor, if it pleased the court, the district court's prior dismissal of this case and ruling that the National Firearms Act is in contravention to our Constitution has no rational basis in the law. The National Firearms Act levies a tax on the interstate commerce in sawed-off shotguns and affixes a federal stamp to the order as proof that the tax has been paid. Mr. Miller and Mr. Layton transported in interstate commerce a sawed-off shotgun without having in their possession a stamp affixed written order for the firearm. That fact is not in dispute. The weapon that Messrs. Miller and Layton transported in interstate commerce, a double-barreled Stevens 12-gauge shotgun having a barrel less than 18 inches in length and bearing serial number 76230, is not issued to any military entity anywhere in our country. To say that this weapon is part of any well-regulated militia is utter nonsense. Gordon Dean knew he had stretched the truth about as far as he had ever had in his professional life. Short-barreled shotguns had been used in every military engagement in the last 50 years, but what Dean had actually said was that serial number 76230 was not government issue, so it wasn't a lie. That's what the lawyer told himself at any rate. The U.S. lawyer looked into the eyes of each Supreme Court justice and felt a trickle of sweat run down his spine. He was searching for any sign that one of these men had seen military service and had used a shotgun with a barrel shorter than 18 inches. If any one of them has, he's going to skin me alive, Dean thought. He pressed on. The National Firearms Act is, once again, a revenue-raising measure. It raises money for the Treasury by levying a tax on certain weapons. Mr. Miller's right to keep and bear arms was in no way infringed. He was merely required to pay a tax on a weapon that has no relationship whatsoever to a militia. Mr. Miller could have paid this tax, and then he would have committed no crime. He also could have chosen to transport a different weapon across state lines, such as a military rifle, and again he would have committed no crime. He failed to pay this tax and then transported the NFA-controlled weapon in interstate commerce. This is a crime, pure and simple. You have the government's brief, Your Honor. Gordon Dean held his breath. He was dreading the inevitable question about the National Firearms Act also restricting commerce in automatic military arms. He also dreaded the question of how a $200 tax on a $10 gun could be anything but an infringement on the right to keep the weapon. As he stood there in front of the U.S. Supreme Court, he could not help but think about the purpose of the second article in the Bill of Rights. The Second Amendment is a recognition of the danger of standing armies. Its purpose is to recognize that every citizen has a right to keep and bear the same type of basic arms as a soldier in a modern military. A militia embodies all able-bodied men over the age of 16. Therefore, a militia will always outnumber a standing army by at least 20 to 1. If this militia is armed with weapons similar to those used by the individuals comprising the standing army, it will be impossible for that standing army to inflict the will of a tyrannical government upon the people. The Second Amendment is the guarantee behind all the other articles in the Bill of Rights. It is the ultimate guarantee that citizens of the United States will remain free. Gordon Dean waited for the justices to look at the wording of the National Firearms Act and ask him, based on his own arguments, how the act could restrict private commerce in not only Stevens shotgun serial number 76230, but also the exact weapons currently issued to infantrymen in our military. I'm not cut out for lying to the Supreme Court. This isn't what I had in mind when I went to law school, he thought. Thank God there's no opposing counsel to bring out the truth. He's beginning to feel physically ill. The questions from the justices never came. May 15th, 1939. World events were coming to a head. The Munich conference had been held 8 months earlier. The British Prime Minister Neville Chamberlain had made his famous claim of having secured peace in our time by acceding to Hitler's demand to occupy western Czechoslovakia with German troops. Although most Americans did not even know how to spell Czechoslovakia, let alone care what happened between it and Germany, in 3.5 months the little man with the toothbrush mustache would start the invasion of Poland. America would soon agree with Winston Churchill's assessment of the seriousness of the Axis threat. Those national sentiments were months in the future on this Monday in May, however. On this spring morning, the Supreme Court would issue a ruling that virtually no one at the time would notice. Further, the ultimate results of the decisions would not fully be felt by the United U.S. citizens for many decades. The court had spent considerable time reviewing the government's brief in this case. It was not often that a district court ruled that a federal law was unconstitutional. It was even rarer that one of the participants not even show up to argue its side of a Supreme Court case or file a brief on behalf of the client. Still, the court considered the government's position in the fairest way that it could, without assuming any facts or statements not presented. The decision, unlike most Supreme Court decisions that would come in future years, was only 4 pages long. The reasoning behind the court's decision was contained in the second paragraph. In the absence of any evidence tending to show that possession or use of a shotgun having a barrel less than 18 inches in length at this time has some reasonable relationship to the preservation or efficiency of a well-regulated militia, we cannot say that the Second Amendment guarantees the right to keep and bear such an instrument. Certainly it is not within judicial notice that this weapon is any part of the ordinary military equipment, or that its use could contribute to the common defense. Gordon Dean's strawman argument had worked. Without opposing counsel, the court was never told that shotguns with barrels of less than 18 inches were used in the military. The court was never informed that the National Firearms Act applied to automatic weapons that were obviously military issue, which would have killed the government's own argument right there. Finally, no one had pointed out, as had District Court Judge Hartstill Reagan, that militia weapons were by definition the personal arms of the private citizenry, and therefore whether or not a particular weapon was issued to Army troops was completely irrelevant. The language of the decision would ultimately cause the government much trouble, however. The wording clearly showed that the Supreme Court viewed all military-issue small arms, as being constitutionally protected. Since the National Firearms Act infringed upon the citizens' right to keep and bear arms, many obviously military-issue small arms, the court should have found the act unconstitutional. But the court did not know about this element of the act, and so the National Firearms Act remained on the books as part of federal law. Jack Miller and Frank Layton, innocent men the day before, were once again guilty of a federal crime. They had no known address, however, and in 1939, tracking down a couple of poor Arkansas hillbillies because a year earlier they had had a piece of steel shorter than a certain length was not top priority for Treasury agents. Jack Miller and Frank Layton were never seen again by law enforcement authorities. In 1939, few if any people complained about the National Firearms Act, just as few people complained about the much more obvious Jim Crow laws that existed throughout the country. Just like the doctrine of separate but equal, the National Firearms Act would remain an embarrassing stain on the nation's fabric for over half a century. Just as with the other civil rights violations, the National Firearms Act would spawn other, more outrageous infringements, like a tumor that slowly metastasizes into ever-widening and ever more aggressive forms of cancer. Finally, as was true of civil rights violations everywhere in the world, the choice would come down to eradicating the cancer or letting it kill the patient. That decision, however, would not happen for more than 50 years. When it did, it would be precipitated by several people who on that May afternoon in 1939 had not yet been born, and one who was then only a year old.